before I wanted to get to the issue of the self-representation of Milosevic in the current state of law, but would you talk a little bit about the victims in the DRC? A lot of your work has been not only coordinating and bettering the quality of the investigations there, but also providing some services to the victims as well.
Sure, no, absolutely. I mean, I'll just pick, a lot was discussed, so to try to put it in the context of Congo, I'm going to work backwards, starting sort of with the victims. I think it's what you talk about. It's an interesting hybrid because obviously Congo is a civil law system. So to some extent, what happens when the victim comes in, they first make a statement to the prosecutor. The prosecutor actually writes the statement, and it's that written statement that's actually introduced into the record. The difference is that during the trial, the victim still has to basically testify and reiterate what's in the statement. Mm-hmm. And all the questions obviously are asked through the judge, even the cross, which is part of the civil system. The trial that I most recently saw, and this again was a mobile court we had organized as part of our Dutch-funded program in Kasango. I was pleasantly surprised. I think both by the caliber, I think, of the trial, of the judges, the prosecutors, but especially the witnesses, because we have, so far we've probably provided counseling to 2,100 victims in Congo, and so out of that, most of the victims, you hear about the cases, but I had never seen a victim testify. And in this particular case, this was a 17-year-old girl who, got up, spoke clearly, told her story, beginning to end, with questions. So that was very impressive. And part of that is because obviously, that wasn't the first time. She had worked with our lawyers. She had met with we have a staff psychologist, and so had been prepared for what was happening. But I think, it's one thing, like you said, sort of, reading about it and hearing about it from our local staff and actually seeing it happen in front of me, where, just the bravery of getting up and being able to do this. And one thing you should know about how mobile courts happen in Congo is that they're completely open to the public. This particular one was actually under a tent, and you had, everybody from 7-year-old boys all the way to, the oldest person in the village coming to hear this. And so I think it took a tremendous amount of courage to be able to do that. But I think what's good is that it is live testimony. Most of the time, at least from what I've read of our cases, they do rely on live testimony as opposed to written testimony, unless they have to. There are some cases, particularly in the case of minors, and a significant portion of our cases do involve minors, where, because it's just not preferable to have them in court, it's done, through written documents. But other things will be introduced, like the medical certificates, things like that will be introduced into the record without the doctor being present, without live testimony.
Right.
So I think that's in terms of, sort of the victims in the trial. In terms of, I think, your previous question, sort of the caliber of, the cases, the defense bar, again, very impressive. Not to say that there aren't issues. There's obviously significant issues, but I would say that those issues deal more with, I think, lack of capacity in infrastructure, technology, not necessarily lack of political will or knowledge base. I think what I found most of the time is that they're very knowledgeable and actually interested in sort of applying the law, principles of evidence, weighing evidence. But, the bigger issue for them is, not having adequate computers, not having enough pens, not having sufficient case tracking systems. Those are the things that are the issue. The way that we've sort of worked on our cases is our sort of local staff attorneys will work with the victim directly and the prosecutor, but the local bar association takes on the responsibility for representing the defendants. So that's actually
gratis.
Yes. And so that's actually a system I think that we found has worked well. So far, we've had about 420 trials. Out of that, we've had 330 convictions, which is about close to an 80% success rate. So
what are people saying in the community? Because the tremendous impact of the opportunity to have this happen in a community and not in The Hague is just provides such a unique.
Yeah, no, I mean, I think that that's key. I think that, you know, obviously, like I said, these are public trials for the most part. And, you know, after one of the trials, I actually went and spoke to a group of women about what did they understand. And again, keep in mind that this is an all-day process out, and it's about 97 degrees. Most of it is open air, and they stayed. I mean, the trial began at about 9:30. You know, there was like a short break for lunch. They came back after lunch. You know, they stayed till about 6 o'clock. I mean, you know, some of them, there wasn't even room to sit, so a lot of them were standing for most of the time. And so I think there's significant interest. And asking them, did you understand, were you able to follow it? And they said absolutely. You know, keeping in mind that a lot of it is in French, and a lot of them don't speak French, they speak Swahili. But for the witness testimonies and any of the victims' testimony, that's actually done in the local language. So I would say the most important parts of the case, they actually do get to hear and do understand. And so, you know, for them, you know, they're saying this is making a significant difference. I mean, just to go back to the case I talked about initially, the case involving the rape of the 2-year-old girl in Kalima, we've seen the cases drop, you know, by nearly 50%. Just by bringing that mobile court to that community. And, you know, and I would say that the biggest test for us was, you know, a case where you had the village chief bring one of the victims to our clinic. I mean, that was significant because normally they would try to work it out with the family. You know, there might be some exchange of, you know, either a goat or an animal or, but they actually, you know, wanted to go through the formal legal process. And, you know, so I think that that's very telling.
Apologize for the distraction. I was telling our panelists, one time we had a delegation of Chinese journalists who were already very nervous about being in the United States, and we brought them into the conference room of the ABA, and all of a sudden, this live, you know, video cam spun around, and God knows why it's on. But anyway, sorry for the distraction. If I could ask one follow-up question, and then I want to open it up for questions, and we've certainly got lots of other things to talk about.
Don't you want to cover self-representation?
Yeah, that's what I was going to do. How did you know? How can you read Judith's book and not get down into the just the tediousness of what happened when Milosevic insisted on representing himself and was granted that right through most of the proceedings? Just some observations, Judith.
Yeah. First, I would say that, you know, in the United States, being able to represent yourself is the right that's been interpreted to be in the Constitution. That is not true in most other countries, and it certainly wasn't true in The Hague. The right is to a fair trial. And you can easily see that allowing somebody to represent themselves who doesn't know what they're doing is not necessarily going to bring you a fair trial. Well, in Milosevic's case, he started out by saying, I don't recognize the legitimacy of this tribunal. I'm going to represent myself, and I'm going to use this as a forum to make my political points and make my history. Well, that didn't sound like, that he was really going to defend himself. But the court, again, bending over backwards, I think, to appear fair, allowed Milosevic to go forward in representing himself. He balanced somewhat, he followed the rules that he needed to follow to not be jerked out. He wasn't the Šešelj kind of a defendant, Vojislav Šešelj, who is also at The Hague, who is flamboyant and does create just havoc when he's in a courtroom and says the most outrageous things.
But still gets away with it.
And still gets away with it, it's true. But Milosevic wasn't that way. He was obstreperous, and he did pursue what he wanted to do, which is to make speeches and to try to make his own history and make the myth of Milosevic as a martyr. And the court was placed then in a very difficult position, because what they needed to do to manage the trial was to constantly try to keep Milosevic in line. So they were saying, Mr. Milosevic, the chief judge, Mr. Milosevic, please, address the issue at hand, or you can't do this, or, So it created the appearance of an adversarial relationship between the court and Milosevic, which is not a good thing. it also added tremendously to the length of the trial. Milosevic began as a very sick man. It didn't happen overnight or while he was at the tribunal. He had a very serious heart condition before he was ever transferred to The Hague. And that was known, as a part of his medical records. Even under those conditions, he insisted on representing himself. Well, what it meant was that he actually couldn't appear in court. You couldn't have a full day of court. In fact, you could only have a half a day. In fact, you could not have a full week of court. You could have, it ended up, slowly it changed over time from 4 days to 3 half days a week. And nevertheless, he still had, there were 66 adjournments during the prosecution's case alone. So I maintain that even though the prosecution's indictment was tremendous, huge, and covered 3 wars, that Milosevic and his self-representation and his illness really contributed significantly to the length of that trial. I don't see how anybody can say that it didn't. At any rate, so that was very difficult. I think the other thing that happened is that the court kept struggling with this, and the prosecutor would occasionally raise the issue again. He's not representing himself well. We're losing time here. He's taking our time away because initially that time was docked from the prosecution's case. And the court said, well, we're not going to change it at this point, though we'll keep the door open. And eventually, midpoint of the trial, prosecution had rested its case. Judge May had to resign, and within a few months he was dead. Milosevic had asked for 2 years to ready his defense case. The court, fortunately, denied that and allowed him 3 months. Well, 3 months went by, and Milosevic was ill part of that time, and he was still ill. And after 6 months, they missed 6 months between the end of the prosecution case and the beginning of the defense case. So the court said it's time for a radical review of this trial. And they ordered new medical examinations and asked the officer particularly to look at, or the doctor to particularly look at, is he able to defend himself now? And the doctor came back and said, no, he's not. And if he does continue this, he's going to kill himself.
And was that which doctor was that?
Which doctor?
Which doctor was that? Because he had several.
He did have several, and there may have been 2 opinions on that. I can't remember right now, but yeah.